Hello again, YouTube. It's Ted Visner coming to you live from Blanchard, Michigan, here to report on a couple continuing stories that are going on that I'm personally involved with. Right now I'd like to talk about the Danny Austin case. As you know or may know from previous videos, proceedings were commenced against Daniel Austin without any notice to her, making the proceedings against her a complete nullity. After finally ridding herself of representation, alleged representation by two different attorneys, the first being a court-appointed, the second being a paid lawyer. You can see those videos on my channel here. Daniel Austin entered an objection to the notice defects in her case, terminating the case itself and declaring it a nullity from its beginning. And what's important right now to understand and realize is that, you know, unless all parties to an action are noticed, they are a nullity. And when Danielle presented her objection to the notice defects in her case, there was no counter-argument to that, because there is no counter-argument to that. And I would encourage people right now to call Risa Scully, because she still has given the authority to DHS, as if she had some sort of divine power to do so, to keep Daniel Austin from her children. And right now, it's almost been a year. Next month, it'll be a year. And during this nullity process, Danielle's being alienated from her children. Allegedly, the court has left it up to Sean Hutchins at DHS to arrange for scheduled visitation, and this asswipe scheduled visitation at a time when the older two children were in school and unable to attend visitation. So there's intentional alienation going on here that needs to stop, folks, and I would encourage you to make some calls. I'm going to put some numbers in the links below. The sheriff is already unconstitutional. Sheriff Leo Medashevsky was involved in the theft of property from my home, and the subsequent cover-up of that in 2010. And Bill Schuette, the Michigan Attorney General, is also completely out of control, completely self-deluded with his own campaign issues and his eye on the president's seat or whatever, and is completely shirking his duties as the people's lawyer here in Michigan. So some phone calls need to be made, and I'd really appreciate some phone support here. Again, I'll be putting these people's numbers down below. They're not going to do anything, but I would like you to comment in the comment section below what they're telling you. We need to call the sheriff and say, hey, you know, proceedings in the Daniel Austin case resulted in the kidnapping of her 3 children. What are you doing about it? You know, what is the sheriff's department of this county doing about it? She was never properly served. I mean, how much clearer does it need to be to drive that point home? Proceedings where both parties aren't properly noticed are null and void from their inception. They don't exist. Okay, and even though Daniel on her own pointed this out to the court simply refuses to look at it. And judges are lying now on the record to preserve themselves at the appellate court level. So it's time now for the people to recognize what's going on here. And if you need to call these public officials, alleged public officials that should be doing something about the kidnapping of Daniel Austin's children, and hundreds of other families across Michigan are in the same boat. Respondent parents are being trapped in a jurisdiction that was unlawfully obtained and is being criminally maintained by the Michigan Supreme Court. Our Michigan Supreme Court is complicit. So where are we supposed to go for justice, for redress? You know, how are we supposed to address these issues when the criminals themselves are the state actors? And we're coming full circle right now, because I've been working with Oath Keepers and 3%ers and militia and Minutemen and the NLA and a bunch of different organizations that are starting to figure out that the key issues that we need to be working on right now are all related to our county courts. CPS in and of itself does not have the authority to do anything without the blessing of the court. And right now the courts are giving CPS carte blanche. Do whatever the hell you want, and we'll just smooth it over in court. And that's kind of how it works. Well, in so many cases in Michigan, the respondent parents are being brought into the jurisdiction illegally. Okay, they're unlawfully. They're being brought in, and when I point to the Michigan Supreme Court as being complicit in this child trafficking scheme, which is exactly what it is, all I need to do is point you to one court rule, and if you take 10 minutes and read this court rule for yourself, you'll understand what I'm talking about. Basically, this court rule traps people in the jurisdiction simply for showing up to court. And keep in mind, these respondent parents are coming to court because their children are being held hostage. So what choice do they have but to come to court? This is key, people. So because the kids are being held hostage by the state and they come to court, now they're trapped in the jurisdiction. And the court rule I'm referring to that was created out of the wisdom of the Michigan Supreme Court to create revenue for the state is Michigan Court Rule 3.920H. Okay? H. Hotel. H. Capital H. Okay, read it. That's all you have to do. Read it. Don't take my word for it. Okay? The Michigan Supreme Court is responsible for the creation of that court rule, which traps parents in a jurisdiction that they don't belong in. Okay? It also is the intentional deprivation of due process, an inalienable right. Okay? A right that can't be given away, can't be taken away. It's inalienable. Everybody has the right to due process. Okay? You can't waive it, you can't give it away, you can't say I don't want it. It's yours, okay? Because you're breathing. You have the right to due process. So, with that in mind, why is the Michigan Supreme Court saying that respondent parents that show up to the hostage negotiations initiated with regard to their own children, they're forever waiving their right to object to the notice defects? And this needs to sink in, people. I really need you to take a look at this court rule. It's simple. Just in a Google browser, type in MCR 3.920 and then H. Okay, it's simple. It's simple. The Michigan Supreme Court creates the court rules. Okay, this particular court rule is the intentional deprivation of due process rights under color of law, which is a federal crime. Okay, so the Michigan Supreme Court is committing federal crimes against the people of Michigan. I'm not making this up. And if I was wrong, I'd be thrown in jail. Okay, those are the terms, folks. You don't accuse the Michigan Supreme Court of committing federal crimes without, at least taking some time to figure out if what you're saying is right or wrong. Because false allegations of crime is a crime in and of itself. Okay? I won't be participating in making up shit, to blow my own horn, because that's not me at all. So the Michigan Supreme Court is creating this crap called the Michigan Court Rules, and under color of law, they're depriving respondent parents in Michigan of the right to due process. What does that mean? Well, essentially what that means is that parents in Michigan can have their children stolen and then get a phone call an hour later to be in court 2 hours later or 10 minutes later. It doesn't matter. Okay? It's the obstruction of justice, and it's the intentional deprivation of due process. Here's the kicker, folks. In your Google browser, type in Title 18, United States Code, Sections 241 and 242. Go to the FBI webpage. Don't take my word for any of this. Read the law, Title 241 and 242, and tell me what those mean to you. Here's the thing. Not only is the Michigan Supreme Court complicit in the deprivation of rights under color of law, the Michigan Supreme Court is also subject, because these are being relied upon, the Michigan court rules are being relied upon to kidnap children. The potential penalty for these federal crimes is the death sentence or life imprisonment. Wow. So the Michigan Supreme Court is committing federal crimes where the potential could be life in prison or the death sentence. And we're just stumbling around out here stupid. We don't know this. We don't understand how the Michigan Supreme Court is complicit in the state's ability to traffic in children, our children. Folks, if this doesn't completely piss you off, I don't know what will. There's no other way to explain it. The Michigan Supreme Court creates the court rules. This specific court rule, 3.920H, allows proceedings to continue against respondent parents who've already been deprived due process. Do you think that the county courts don't know this court rule, or don't understand this court rule? That's wrong. The counties in Michigan are relying on this court rule to formulate the strategy to get the respondent parents into court in the first place. Do you understand what I'm saying? The counties in Michigan are relying on 3.920H to intentionally deprive respondent parents in Michigan out of the gate, knowing that any parent that cares at all about their child is going to appear. And that very appearance, according to the Michigan Supreme Court, waives that parent's right to object to the notice, defects, trapping the parent in a situation where they've already lost. This is the case in the Daniel Austin case and probably hundreds already of others that I've learned of in Michigan. Folks, share this video. It's not for me, it's for the people, okay? I don't want to be cutting videos, but here I am. Here I am in your face with the truth. Our judiciary is gone, okay? The Michigan Supreme Court is a terrorist group. If you have never had your children away from your side, you might not know what I'm talking about here. Walk away from your children for a week even and tell me it doesn't hurt. Even if you know they're safe and in safe hands with friends or family. Now superimpose the state over your friends and family and make it a year. And tell me that's not terrorism. Okay, I wanted to keep this short. This video needs to get circulated. This actually is a blueprint used by a lot of different states. Okay, the intentional deprivation of due process under color of law, where there is a penalty of death. The Michigan Supreme Court should be strung up after due process, of course, but their complicity cannot be denied. Okay, they create the court rules. It isn't by accident. This isn't some oversight. They make the court rules that are hanging respondent mothers and fathers in Michigan and screwing our children's future, screwing up their lives, exposing them to crap they don't need to be exposed to, all for the sake of making money for the state and the county. Nothing could be wronger than this. People need to get their mind around this. It's really simple. Okay, that's one of the things that I've learned in all my dealings with the state is you got to keep it simple. Well, here it is, folks. Michigan Court Rule 3.920H. That's it. Type it in, read it. It's a single paragraph. This paragraph robs people intentionally of due process rights. Inalienable due process rights. Till next time, Ted Visner signing out.